So today, the Supreme Court heard an important case that it should not have been here. And it revolves around a conservative Christian web designer in Colorado who wants an exemption to a state law so she doesn't have to design websites for same-sex marriages. And the reason the court shouldn't have been hearing the case is because nothing's actually happened. No injury has occurred because no one has asked her to make a website or forced her to make such a website. It hasn't happened. She just preemptively sued the state of Colorado, arguing that should that happen, her First Amendment rights would be violated. She has a First Amendment right to refuse to make hypothetical websites for hypothetical same-sex couples because of her actual beliefs. And because the conservative majority has tossed away all pretense of being anything other than essentially a high council of Fox News viewers, they decided her case should be heard before the Supreme Court of the United States of America. Very, very few cases get to do that. And so today, they were hearing the case, making the arguments, and sounding more like callers into a right-wing radio show than Supreme Court justices. Just listen to how Samuel Alito responded to a hypothetical situation raised by Justice Ketanji Brown Jackson. Jackson saying, "Can you give me your thoughts on a photography business in a shopping mall during this holiday season that offers a product called Scenes with Santa, and this business wants to express its own view of nostalgia?" Jackson continues, "Because they're trying to capture the feelings of a certain era, the policy is that only white children can be photographed with Santa in this way. The objection, just like your client's objection, is to expressions that violate their own views of what is being depicted." Alito, "So if there's a black Santa at the other end of the mall and he doesn't want his picture taken with a child who's dressed up in a Ku Klux Klan outfit, that black Santa has to do that?" The lawyer, "No, because Ku Klux Klan outfits are not protected characteristics under public accommodation laws." Kagan, "And presumably that would be the same Ku Klux Klan outfits whether the child was black or white or any other characteristic?" If you, viewer, are like, where is this going? Alito, "You see a lot of black children in Ku Klux Klan outfits, right? All the time." There was a lot of laughter in the courtroom at that moment, although very confusing. Then there was Justice Neil Gorsuch raising the case of a Colorado baker who refused to make a cake for a same-sex couple and was told to undergo non-discrimination compliance training.
Mr. Phillips did go through a re-education training program pursuant to Colorado law, did he not, Mr. Olson?
He went through a process that ensured he was familiar with...
It was a re-education program, right?
It was not a re-education program.
What do you call it?
It was a process to make sure he was familiar with Colorado law.
Someone might be excused for calling that a re-education
I strongly
program.
disagree, Justice Gorsuch.
Thank you, Mr. Olson.
Re-education program, of course, is a reference to Maoist camps during the Cultural Revolution. The arguments lasted for 2.5 hours. It seemed pretty clear which way the conservative majority will eventually rule. I'm joined now by Melissa Murray, professor at New York University School of Law, co-host, along with Leah Lippman and my wife, Kate Shaw, of the Strict Scrutiny podcast, and Elie Mystal, the justice correspondent of The Nation. And it is great to have you both here in person. So I want to just start with this initial point, and I should say that Kate made this point to me when she was giving me her own tailored preview for me about the case a few weeks ago, and I just couldn't believe that it was true, which is that the plaintiff has sustained no injury, right? I'm not missing this. No one made her make a website, right? There's no dispute between two parties like that's happened. This is purely a hypothetical about the future.
Purely hypothetical, purely speculative, purely theoretical. And it's the reason why you had all of these completely outlandish, kind of offensive hypotheticals from Justice Alito and company. I mean, the black children in KKK costumes. None of this would be happening if we actually had facts on the record that could be discussed in this case.
Right. And so instead, you got this very weird, almost kind of law school riff session in the arguments today that were really strange and very long.
Yes, but there was a point to them, right? And what they were trying to do is completely misunderstand the nature of rights in this country, right? So the right wing really loved to go to these racial analogies, to go to these KK analogies, trying to suggest that anybody who is against same-sex marriage is like the KKK to a black person, right? So like that was the kind of Samuel Alito being a 4chan troll. That was the kind of thing that he was trying to do, but they fundamentally misunderstood the law, right? Because here's the deal, Chris. One of the ones they used was the black carpenter who makes crosses but doesn't want to make a cross for the KKK.
Right.
Isn't that discriminatory? No, it's not discrimination, because if I'm a black carpenter, I can easily say I don't want to make crosses for the KKK. What I can't do is say I don't want to make crosses for. What I can't say is I will not make any crosses for white folks.
Yes.
Now it is Sam Alito and Amy Barrett who seems to think that there is no difference between white folks and the KKK. I happen to think better of white people and think that there's a huge difference between a white person who wants a cross for a religious ceremony and a white person who wants a cross for a Klan rally.
So this is where we kept coming back to, which is the case, and in case people aren't tracking here, right? We've had the Masterpiece
Cake Shop.
Masterpiece Cake Shop. That is the Christian bakers who don't want to bake a wedding cake for a gay couple, right? That is a religious protection, right? So we want to carve out from these sort of generally applicable non-discrimination laws that if you have a religious objection. So that's Masterpiece Cake Shop. This is not that, right? This is under the First Amendment saying you can't compel me to make speech I don't disagree with.
Well, so let's first be clear. When Lori Smith, who is the plaintiff in this case, brought her suit, she did have a religious liberty claim. She was essentially arguing that it violated her rights to free exercise of religion to be compelled to serve same-sex couples by providing websites. But
even though no one is masturbating,
even though she hasn't served anyone, the theoretical gay couples. But she also has this compelled speech claim. When the court granted certiorari on this case, they only granted it as to one issue, the compelled speech issue. Why they didn't touch the religious question, up for grabs. Maybe it's because they've done so much to expand the scope of free exercise over the last couple of years. Maybe it's because there are individuals raising free exercise claims in response to limitations on reproductive rights. Who knows? But maybe it's also because this case was literally created in a lab to bring this question to the Supreme Court. And so it's a compelled speech case. She's arguing that Colorado is making her say that she endorses same-sex marriages, which she does not because of her religious views. But what's missing in all of this, while we're talking about Lori Smith, while we're talking about the prospective speculative injuries she may or may not suffer, is we're not talking about the actual same-sex couples who are going to be denied equal treatment in the marketplace. And that's the thing that really was lost in this entire argument. She was the victim. The other victims of discrimination were completely absent from this.
It's because the case was already determined before the judges heard a single argument.
Right.
The real issue is, and there's a scintilla of a point here, right? Obviously, the government cannot compel you to say anything, right?
Right. You can't say everyone in Colorado has to write an op-ed saying they like same-sex marriage. Clearly not.
Government clearly can't compel you. Can't. So what Lori is trying to say, what the website designer is trying to say, is that she has a content-based reason to discriminate against the messages that she's willing to do, and she is right to have that content-based discrimination. However, what she's doing is going for status-based discrimination. So she's trying to say that gay people can't come into my store.
Right.
Not that she, because as we all have been saying, no gay person is asking her to do anything, right? But she's trying to say that gay people can't even come into your store, and that's something that takes us right back to the Jim Crow era. Because it used to be that the racist lunch counter people were just like, I have a religious objection to black people at my store. You can't say that. We've moved beyond that. People like Sam Alito are trying to take us back there.
It seems to me that you've got this weird perverse thing happening in the court, if I can sort of step back, when you look at the First Amendment, which is we think about the First Amendment sort of protecting rights. And obviously it protects rights in a complicated way because some rights are in tension within the umbrella of the First Amendment. But going back to, say, Citizens United, right, which is a First Amendment case, this sort of use of the First Amendment as this kind of weapon for the dominant group versus the marginalized group, for the powerful rich billionaires versus the voters and public interest, where all of a sudden this thing looks like it's being used by this particular majority on behalf of folks who already have a kind of disproportionate power.
Let me put it in context. A couple of weeks ago, we were talking about the affirmative action cases that the court was hearing, and that was a case that was sort of brought under the question of the Equal Protection Clause, this part of the Constitution created to bring formerly enslaved individuals into the body politic as citizens. What we are seeing from this court is a refusal to use the Equal Protection Clause to redress racial injuries unless they happen to white people. Whereas we are perfectly happy to expand the First Amendment for the purpose of remedying these imagined injuries, expand the Second Amendment to remedy these imagined injuries, but we won't do it in this way that was actually intended by the framers of the Constitution.
There also just seems to me, I mean, the Gorsuch line there, with the re-education camp. I mean, look, it's true. Scalia was never pretending where he was coming from in cases. I mean, famously, right? Like, you sort of knew where he was coming from, and he was quite sort of like forthrightly ideological and pressing the people. But it just like, I was just so struck by that moment where it's like, you're giving away the whole game when you're trying to like bully the lawyer into calling compliance training re-education camps or re-education classes. What even are we doing? Like, you've given up the pretense that you're doing any judging. You're like, we know where you're going to end up.
Yeah, they're all in the same bubble. They're all in the same right-wing echo chamber where they all talk to each other and they think that things that aren't real are real. It's not all that different than what we see happening with Republicans in Congress, right?
That's a good point.
They're all...
Or at the state legislatures. I mean, this is the same kind of line against CRT being taught in elementary schools, which never actually happens.
Camps,
yeah,
right.
same idea.
From my perspective, there's almost a good thing here because for too long the Supreme Court justices have hidden behind a veil of secrecy and a lack of transparency where people think that they are impartial arbiters.
Balls and strikes, right.
And what's happening right now is they are showing you just how desperately partisan they are, and they're willing to make themselves sound like fools to do it.
Yeah, and the neutrality robes that they don, which are literal cloaks to like costume themselves as neutral arbiters of the law, like can't mask what we're hearing when they're talking about re-education camps. Melissa Murray, Elie Mystal, great to have you both here.